Buckle up, folks, because this is one of those days in Harris County where the courtroom sees it all, from a questionable DWI stop to a mystery temporary tag that leads to a deep dive into immigration consequences. In our first case, a man accused of driving while intoxicated faces up to 6 months in jail. The officer says there was the smell of alcohol, but that's pretty much it. No bloodshot eyes, no slurred speech, no swaying, just the faint scent of something that could have been from a tattoo parlor antiseptic. And you won't believe how the judge reacts to that explanation. Then, our second case brings us to a man charged with tampering with a government record after police read a temporary tag that didn't check out. But here's the twist. There's no clear proof he knew it was fake. Both cases test the limits of probable cause and the balance between suspicion and evidence. Stick with me, because what happens here could change how you see these quick courtroom rulings, and I promise you'll want to weigh in on who you think walked out with justice on their side.
Good morning, Mr. Ramirez.
Morning, sir.
Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Thank you, Your Honor. On April 17th, 2025, in Harris County, Texas, an officer observed a pickup truck change lanes without using a turn signal. The officer observed the vehicle change lanes twice prior to initiating the traffic stop. The officer approached and observed the defendant to be the driver and sole occupant of the vehicle. The officer noted a strong odor of alcoholic beverage emitting from the defendant. The defendant was ID'd by his Texas driver's license. The defendant stated that he did not know how to provide proof of financial responsibility. As the defendant responded to the officer's questions, the officer noted an odor of alcoholic beverage emitting from the defendant's breath. Standard field sobriety tests were conducted. A 6 out of 6 was reported on the HGN, and the defendant stated that he could not perform the walk and turn or the one-legged stand. The DIC was read, and the defendant refused to provide breath or blood voluntarily. A blood warrant was obtained and the defendant's blood was drawn.
Your Honor, may I respond?
Please.
Okay, first of all, Judge, the reason, it's not on there for some reason, but the reason he told the officer he can't do it because he had surgery to his back and to his knee, he can't do it. Secondly, there's no mention of any slurred speech, no bloodshot eyes, no swaying.
I was actually thinking about that as well. All you have is an odor of alcohol. There's no accident, it's just a turn. All we have is an odor of alcohol. Is there anything else? The odor alone is insufficient.
No, Judge, he was coming from a tattoo shop and the police officer asked him, is he alcohol because of the tattoo?
Is he what?
He just had a tattoo put on. That's just coming, so that's the odor of alcohol.
Come on, man.
I'm just saying. I mean, the officer actually asked him that question.
What are the little alcohol that you put on your skin, you're telling me that?
I don't know how it works, Judge, but I've never had a tattoo.
You're killing me, Smalls.
Your Honor, the law enforcement officer does state in the DIMS that there is a distinct odor of an alcoholic beverage emanating from the defendant's breath as he spoke.
Okay, yeah.
That's all we have before we initiated the standardized post-sobriety test.
Okay. And there it is, the pivotal moment. After hearing the state's evidence, the judge makes it crystal clear. Odor of alcohol alone doesn't cut it. Under Texas law, probable cause for DWI usually requires a combination of factors: poor performance on field sobriety tests, visible impairment, erratic driving, or even admissions of drinking. Here, all we've got is a lane change without signaling, and a scent the defense argues could have been from antiseptic used on a fresh tattoo. That's a far cry from the rock-solid evidence prosecutors need. But here's where I want your take. Do you think the judge made the right call? Or should refusing a breath and blood test tip the scale toward probable cause? Drop your thoughts in the comments, because this is one of those rulings that divides opinions fast.
Okay, that's not enough. All right, I'm gonna find no probable cause in your case, Mr. Mears. You know, we have enough debt on our streets now, you know? $40. One button will get you a car wherever you want to go in this life. You know what I mean?
Yes, sir.
Use it. All right, please.
Thank you.
Mr. Aiko Stoll, you were charged with tampering with a government record. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Your Honor. On April 19th, 2025, in Harris County, Texas, a law enforcement officer ran a temporary tag on the defendant's vehicle that did not come back to anything, and the officer initiated a traffic stop. The defendant stated he did not have the title to the vehicle, and a second check on the temporary tag did not come back to anything.
Did he say that? Read it to me again. I zoned out. Please.
The law enforcement officer ran a temporary tag on the defendant's vehicle that did not come back to anything, so he initiated a traffic stop.
Okay.
The defendant stated he did not have the title to the vehicle, and a second check on the temporary tag did not come back to anything.
Did he ask him if he put the tag on there? Did he ask him? I mean, let me see how it's charged. Did then and there unlawfully, intentionally, and knowingly present the thing attached hereto as Exhibit A with knowledge of its falsity and with the intent that it be taken as a genuine governmental record. That's a specific intent crime, you know, somehow you have to show me that he knew of its falsity.
Judge, I'll just read straight from the DIMS. I met with the defendant and informed him of the reason for the stop. I then asked for a Texas driver's license and provided me with a Guatemalan ID. I then asked the defendant when he bought the vehicle. He advised me that he bought the vehicle 3 months ago. When I asked the defendant if he has the title to the vehicle, he then advised me that the guy who sold the vehicle still has the title. The defendant stated that he bought the vehicle 3 months ago again. When asked for the title, he stated that the guy who sold it still has the title again.
I'm going to find that there's no probable cause to go forward.
Once again, the judge rules there's not enough to move forward. And this time, it's about proving intent. Tampering with a government record isn't just about having a bad temporary tag. The prosecution must show beyond reasonable doubt that the defendant knew the tag was false and intended for it to be accepted as real. Here, the man claims he bought the car 3 months ago. The seller still has the title, and there's no direct admission that he knew the tag wouldn't check out. Without that key piece, this case crumbles. But notice how the judge pivots, immediately warning the defendant about the risks of driving without a Texas license, and even hinting at immigration consequences if he breaks the law again. That's a reality check that goes way beyond this single hearing.
Your case, Mr. Aiko. If you do not have a Texas driver license, you are not allowed to drive. At some point, if you continue to do things that may break the law, you go to jail and immigration finds you, they will put an immigration detainer on you and you will be stuck like Chuck. I don't know what your immigration status is, but if you're not in this country with permission, you must live like you have a halo above your head. If not, there are serious consequences. Do you understand? Please take a seat. Thanks, Boston.
2 cases, 2 dismissals, and both hinging on the same legal standard, probable cause. In the first, the state leaned too heavily on a single piece of evidence, the smell of alcohol, without other signs of impairment. In the second, prosecutors couldn't bridge the gap between suspicion and proof of intent. These rulings show just how much the burden of proof matters, even at the earliest stages of a case. It's a reminder that while the courtroom may seem fast-paced, every word, every fact, and every missing detail can make or break the state's argument. So, what do you think? Did justice prevail here? Or did two people walk away on technicalities? If you found these cases as fascinating as we did, make sure to hit that like button. Share your thoughts below, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.